Welcome all the distinguished guests on and off the dais, and I ensure that I'll comply with the timeline that is given by me, Mr. Sourish Das gupta. So today's subject is Independence Electricity Act Amendment Bill 2014, and I'll be specially focusing on the implication of the carriage and content separation. So the way today's presentation has been structured, there are three broad categories. So Electricity Act Amendment Bill 2014, its background and what all its broad level implications, and what are the key issues that we are envisaging that this new amendment with regard to separation of the carriage and content will invite, and what are the opportunity that it will throw to the different market entities who are operating in the power sector. So let's start with the Electricity Act Amendment Bill background and its implication. So if we look at because there are many speakers before me who have already talked about it, there would be a bit of repetition. So, but nonetheless, let me again touch upon very briefly the big facets of the Electricity Act Amendment Bill. So it mostly talks about the significant reorientation of the distribution and supply business of the existing licensee. So in terms of what we are saying, the separation of the carriage and content. And it also proposes significant measures in terms of promotion of the renewable energy, and it offers measures for the tariff rationalization, enhancements, grid safety and grid security. So coming to the next slide, so if you look at the overall journey of the Electricity Act Amendment Bill, so let's go back in 2003 when the Electricity Act 2003 got introduced, and subsequent to that January 2004 when there have been many amendments to a few sections of the Electricity Act 2003. And then it is April 2012 when a committee being constituted to examine the amendment of the Electricity Act. And right now it is 11 December 2014 when the Union Cabinet approved it. So there had been a long passage of time that has gone by to come this far. And now if you look at what is the present status of the amendment, the bill with the Parliamentary Standing Committee has already been approved and it is likely to be discussed in the current budget session. So again, the Electricity Act Amendment, the four key features, enhancing the efficiency and competition in the distribution sector, that's what it is aiming at, and strengthen the grid security and safety, promotion of renewable energy, and also it talks about tariff rationalization. So out of all this, we'll briefly touch upon the separation of the carriage and content or the distribution and the supply business and its implications. So we have not reproduced all the acts and its notification and the section and subsection, but broadly the left-hand column talks about the proposed provisions and the right-hand column talks about broadly what are all the likely implications of it. So firstly, we are talking about the separation of carriage and content in distribution segment. So this will lead to having separate distribution licensing and multiple supply licensing in an area. So as Mr. Karandikar said, you will have generator, you have transmission and then distribution and also, but you will end up having multiple number of supply licensing. So distribution licensing may not engage in trading or supply of electricity as per the proposed amendment. So these actually stipulate a kind of a, embargo upon the distribution licensee that they will not be able to also get into much in the big way into generation because they ultimately need to end up selling their electricity and may need to get into the trading activity. But yeah, there could be different industry structure that can be proposed in terms of SPV, in terms of many other ways. So that need to be looked into for any market entity to operate in this field who are presently operating either as a generator or as a distributor or as an integrated utility. So appropriate commission may grant a supply license to two or more persons in the same area of supply, and out of that one of the supply licensee will be a government controlled company. So that is again a very key feature. If you look at that, one of the supply licensee has to be a government control company. And as one of the earlier speaker rightly said, if one of the distribution supply licensee is a government control company, then of course there would be, because he will be having the benefit of being a sovereign guarantee, being in favor of him, raising the loan, being much profitable player in the market. So those benefits would be automatically accrued to the supply company, to the government control company, and in that case, this may actually break out the uneven competition. And the existing distribution licenses to continue till expiry of their term as specified in the licensee. So there is a bit of uncertainty that will actually induce a bit of uncertainty in the system with regard to the operation of the existing distribution licensee. So wherever you are having the private distribution companies operating right now, and they may be asked to, split in the distribution and the supply business, and of course they need to choose whether they would be the distributor or they would be the supplier. So there would be a bit of uncertainty with regard to the operation of the existing distribution companies as well, if this amendment is getting enacted. Now the next few provisions with regard to again separation of the carriage and content. The state government shall within the period specified under 51A draw up a transfer scheme of functions, property, rights and liabilities existing PPAs and arrangements. So now this is one thing that need to be looked into in a much bigger way. So there are already private distribution companies which are operating in the country. Now tomorrow, just through this amendment or through this bill, you are bestowing the state government with the responsibility that they can introduce a transfer scheme in order to segregate the asset of the existing distribution company. So, and those are private players. So whether this would be within the purview of the government to notify such a transfer scheme or to make that operational, this is again something, and how much and how the transfer scheme is going to actually operate on this, that also need to be looked at. A supply licensee designated as a provider of last resort with obligation of supply licensee to consumers in a supply area. So again, this will lead to, because we have already talked about the cherry picking, so you will be having one distribution player, one government controlled company who will be there as a supply licensee, and there will be many other supply licensee operating in the same area, and with the incumbent supply licensee also being there for some period, so there could be an issue of cherry picking that could also plagiarize the overall motive of the amendment bill. And the area of supply licensee, thou it is specified, so we believe there is a lack of clarity with regard to defining the area of supply licensee, and this again may lead to the issues of cherry picking and so on and so forth. So now on this, what are the key issues that we think that need to be looked into? So either of the supply or the distribution functions of the existing distribution licensee required to be transferred to another party. So there is an ambiguity with regard to the provisions on ownership of the transferee that can lead to a state government discretion during transfer. So again, the existing private distribution company and their business, the way it would be transferred, that would be completely based upon the purview of the transfer scheme that the state government is going to initiate. And if you look at the proposed amendment, the way it is existing there, there is no provision that the state government will follow a consultative procedure with the private companies or with the other discoms in order to figure out the modus operandi, the way the transfer scheme is actually going to operate. Power provided to the state government to notify a transfer scheme for separation of carriage and content business for even the private distribution business. Again, that's what I kept saying, it is a bit intrusive for the state government to look into the modus operandi of the private distribution business and separate or their distribution assets, their PPAs and their assets and their liabilities, and to allocate them to a new supply licensee. Where multiple distribution licensees are operational in the same area, ambiguity on which entity will be the incumbent supply licensee. Exactly. So for a city like Bombay, where you already have multiple distribution licensee, during the transfer period, so it's still not clearly specified which one would be the incumbent supply licensee. Then subsidizing consumer categories will likely be asked for competition and cherry picking, an appropriate commission to determine the tariff base. So again, for the supply tariff, they have stated that the appropriate commission will determine the ceiling tariff based on normative cost and standard of performance. This is kind of broad principle of the game, but how the game will be played, what will be the macro and micro and granular rule to play the game, that is not determined through this amendment bill. So it talks about, okay, there would be a normative tariff, there would be a ceiling tariff, and the appropriate commission will determine, but what all the underlying principle, underlying rationale through which this tariff is going to get decided, that is again not very clear. So that's where I stop on the key issues. So I move on to my next section, that is the opportunities. So again, the opportunity, I would very briefly touch upon it. So many more companies to enter into the power sector as a electricity supply licensee. That is definitely one of the opportunities that it throws up. Possibility of emergence of the local and niche players in the electricity supply sector. So who are earlier restricted to any specific area. And if you look at the last point, if you look at the overall cost structure for the supply licensee, there is a very limited room open for the competition, because the selling tariff will be decided by the appropriate commission and the cost also will be quite a bit similar for most of the supply licensee. So there comes the role of the smart metering and the technology interventions, though of course the cost of smart metering or the cost of the other technological interventions and the way it will bring in efficiency that need to be looked at. But again, for the technology companies, this may provide some big chunk of opportunities. So that's it. Thank you.